Simon joins us now. Good morning to you.
Good morning, Mike, and good morning to the platform listeners.
Good on you. Now, listen, the Privileges Committee took charges against you for, leaking information from was it an Environment Committee of the House?
That's right. Parliament is made up of select committees that are supposed to look into government's bills. We have submitters who come and tell us, whether they're from industry or individuals, their concerns about a particular piece of legislation. In this case, it was David Parker's replacement for the RMA, the Natural and Built Environments Bill. And what submitters have told the Environment Committee is they're really concerned about all of these undefined terms like te oranga o te taio, which means to apparently something about the environment, and mātauranga Māori, which I thought, if you look in the Te Reo dictionary, meant Māori knowledge, but which the government refused to define in the Natural and Built Environments Bill. And I wanted a definition because I thought it's important for decision makers, whether they be judges or planners in a council in the future, to know what mātauranga Māori is meant to mean.
Well, I'd also quite like to know what the knowledge is too. Interestingly, just on that issue, my council, because I'm an elected member of the Otago Regional Council, made submissions on exactly that issue, Simon. We said that there were imprecise definitions, particularly of Māori terms, te ao Māori being one of them, and we wanted it defined in the legislation as well. So your concerns would seem to have got a common chord through much of the local government sector, who now are going to have to interpret this legislation were it to be passed through the House. Okay, so there you are. You say you want to do that. Presumably there's a vote at the Select Committee as to whether or not to include that definition into your report back. Is that right?
Well, that's right. I mean, sometimes we have discussions between MPs at Select Committee, and the committee agrees essentially unanimously to go down a certain course or to include a certain piece of discussion in a committee report back to the House. But in this case, the Labour Green majority, refused to even allow me to ask officials a question. And so I said, well, I want to put that to the vote. I want that on record, that the majority refuses even to allow the discussion of this term or to allow a definition to be included in the bill. And so there was a vote, and of course I lost. I was supported by the national MPs on the committee. And at that point, my interpretation of standing orders, now, Michael, I'm a civil engineer, not a lawyer, was that having made a decision that the committee's decision could be discussed openly. But it turned out I was quite wrong, and the Speaker has rightfully corrected my interpretation.
So I don't get that bit, and I don't think anybody listening to this either does. It's a select committee. You're dealing in public with a particular piece of legislation which has been called for public submissions. You're going through a discussion, I guess, in a deliberation phase. Why wouldn't any of that process, including that vote, be public information?
Well, it always will become public information, but not until after the committee has finished its overall deliberations and consideration. And so the error of judgment I made was in assuming that that the committee would not allow a definition of mātauranga Māori to be included in the bill. We had voted on it. I assumed that the matter was closed, and therefore it would no longer be subject to parliamentary privilege or confidentiality. And so that's why I was prepared to talk about it and did a media release on the day, because I thought Kiwis deserved to know. But of course, until the bill, the committee reported back to the House on the bill, it was not able to be discussed. So look, I've accepted that, but I think the important point is, Michael, and for your listeners, a lot of stuff goes on behind closed doors in government that affects the way we live our lives. And the resource management reforms, this Natural and Built Environments Bill, is going to do just that. What we've discovered, including testimony from local councils and from lawyers, it could take a decade to work out what all these terms mean through the court. None of that's going to make it easier to get a consent to build more renewable energy, to upgrade your port for the largest ships bringing 10,000 containers to New Zealand, or to build transmission lines we need for electricity. It's going to take a decade to work out what this stuff means before we can get New Zealand building again, and actually that's completely unacceptable. We've actually offered our own alternative, Act solutions for building New Zealand and conserving nature, which sets out a really simple way to separate environmental protection from development. Two separate laws for that rather than one, because it's that mixing up of spiritual, environmental and infrastructure permitting that has got us into this place in the first place.
Well, and I mean, there are two things that obviously that come from that. The first, I think you'd have to say, is that this Parliament, not one that you've been a part of, but a prior Parliament, made the huge mistake of not defining what the principles of the Treaty of Waitangi were when it put it into legislation back in the late 1980s. And, wow, here we are still in 2023, debating, defining, and allowing non-elected personnel to define what those principles are. And what you're suggesting to me almost is this is part two of that. Put in mātauranga Māori, which, as you say, is Māori knowledge. What Māori knowledge is specifically you're talking about here. Put in te ao Māori, which is the Māori worldview, which, as you say, has a spiritual dimension. It believes in the supernatural, should be involved somehow, and whether or not you grant resource consents. Bizarre to me, but there you go. Then it's just, you're just letting the courts have this issue for the next 50 years as to how to interpret this, surely.
Well, that's right. And it's not going to help New Zealand get ahead. I mean, we are at a crossroads now. New Zealand could either become a really nice place to visit, but with crappy roads and uncertain laws like Fiji, or we could return to our place as a first world nation with really good infrastructure where the rule of law is clear. So if you or I were to take an application for consent to do a housing development or to put up a warehouse, a distribution warehouse for our business, we would know exactly what tests we had to pass to demonstrate that we were minimising our effects on the environment, whether it's dust, noise, traffic or whatever, and then how long it might take to get the consent of what that might cost. But if somebody can turn up in court and say, well, we don't think in terms of te ao Māori or tamana o te wai that you've respected the spiritual values of the water that runs through your site, how on earth can you argue with that? That's completely against the rule of law, which means that when you turn up in court, you should know what punishment or what opportunity is available to you. And ACT says that has to go. We need to define the principles of the treaty, and we need to make sure that our laws are clear so that people can get on with actually building things and living their best lives rather than trying to work out what some esoteric definition of spiritual matters might be.
Well, I mean, as a general principle, do you believe that the supernatural or the spiritual side of any culture or at all should be involved in the Natural and Built Environments Bill?
No, but that's not to say that we shouldn't respect other people's cultures, because that's one of the things about living in a liberal democracy that's wonderful. I'm personally quite open to whatever cultural practice that is healthy and contributing to society, whether it's your religion or you want to stand on top of a mountain and pray to your gods, that's all great. But it can't possibly be included in decision-making about whether someone builds a farm shed or where the road goes.
Well, that's exactly the point that I'm trying to make. I'm an atheist, and I am applying for, or I'm a Christian, and I'm applying for a resource consent. Why should somebody else's religion be influential in that decision?
Well, it certainly shouldn't. I think we also have to consider potentially what mātauranga Māori might contribute if it was well defined, if we put the spiritual dimension to one side. Because if you think about New Zealand's geological record, where the tsunami hit, where the earthquake happened in prehistoric times, and I mean before Europeans came here and started writing stuff down. If there was an oral tradition that allowed us to link the observations of the people who lived here at the time with the geological record, it might actually tell us, hey, when the tsunami hit, there was a village here that got wiped out. That might be very helpful for planners and decision makers now. And that's one of the reasons why I wanted a definition in the Mātauranga Māori included in the bill, because I actually thought there might be something practical here. But let's make sure with that we define what it is that's going to be helpful to decision makers and to people who want to build stuff, rather than leave it up to the courts to take a decade to decide.
It's just even being in there is problematic to me, because I would have thought mātauranga Māori, because it isn't defined, as you point out, and you've just defined one aspect of it, which is an oral tradition. Again, how does an oral tradition have any structural moment when it comes to whether or not a consents officer from, I don't know, the Hawke's Bay Regional Council determines whether or not I can take an irrigation take from a river?
Well, you're quite right. And if you look at some of the studies done on traditional knowledge, say, of flora and fauna, I've recently read a paper about local iwi and hapu understanding of the habitat of tuatara, and 5 out of the 7 elders interviewed had completely different understandings of where tuatara lived and what their origin story was. Now, if you were a decision maker in court trying to interpret that, it wouldn't be helpful. But I think it may well be helpful to look at Indigenous knowledge, and it is certainly done around the world, when it comes to actually geophysical matters, like what happened when the flood came, if there was some information about that. But that wasn't to be. So even though I was trying to be practical and trying to offer solutions around what can be quite a sensitive topic, the committee wasn't having a bar of it.
Okay, now, the Natural and Built Environments Act, a ridiculous name for an act, but there you go, is going to be a partial replacement of the Resource Management Act, which everybody accepts requires reform, but David Parker, the Minister for the Environment, seems to throw in the baby out with the bathwater on this one. Will it be passed prior to Parliament rising this session?
It's likely to be passed in the next few weeks. Yesterday and again today, we will be debating Minister Parker in the committee stage in Parliament.
Right.
We've had an extended sitting over the last few days. But I think the Minister and the government are sick of debating it. I think they just like it to pass as quickly as possible. But it doesn't resolve the fact that there are still so many undefined terms and novel concepts. The Minister himself dropped a 900-page supplementary order paper or amendment to the bill. Almost every clause on every page of his original bill has had to be amended as a result of the committee's recommendations. And it's still not right. He was dropping amendments on the table at 2 minutes before he was due to speak on his own bill on Tuesday. So it's going to be passed, but it's going to be a complete mess. And what ACT has said is, should we have the privilege of being part of a future government, we will repeal it, and we will instead replace it with a policy that we've already developed and released in 2022, ACT Solutions for Building New Zealand and Conserving Nature, which your listeners can find at act.org.nz. Make it easier to build practical policy solutions for New Zealand.
Good on you, but in the meantime, if that act passes and gets royal assent prior to election day, and just let's say you do get elected in concert with the National Party and get into a position where you can revoke or repeal this legislation, you're then going to have to come up with a replacement to it. And in the meantime, there are regional and councils and territorial authorities all over New Zealand who are going to have to implement what's in that act and interpret. Will you be sending some sort of message out after the election, should you be elected, Simon? Hang on, help's on its way. Don't move just yet.
Well, you're absolutely right. That will be necessary, and it won't just be for the Natural and Built Environments Bill. We think that Labor is going to try and push through its 3 waters bills as well in the next 5 weeks before Parliament rises. So we'll be sending out a whole lot of stop work notices to local government, as well as to the government departments like Department of Internal Affairs and Ministry for Environment, who are trying to implement these bad laws. We'll just be telling them to down tools.
Okay. All right. Thank you so much for joining us, Simon. Best of luck for the rest of the parliamentary week. That is Simon Court, the ACT Transport spokesman. And he fell... the Privileges Committee. What's the Privileges Committee? Somebody asked me. The Privileges Committee is a representative of all parties in the House. It essentially is Parliament's way of regulating its own activities. That's the best way of describing it. So if you go off the reservation in terms of not discharging your statutory, or more likely your your sort of ritual obligations to the House, determined over years of practice, you can be brought in front of the... and that, as Simon Court's done, for example, in that particular case, he gave the example that he breached confidentiality, so he released the result of a vote prior to it being reported back to the House. So he just was a bit too quick off the gun, in essence, and was found guilty. Jan Tinetti, for example, was found guilty of lying to the House. I don't think they actually said it was lying. I think they said she misled the House, whether it was appropriately or inappropriately. So it's that sort of stuff. What else can you be done for? Or abusing the Speaker. You know, a number of speakers have been told to get effed, and with the threat of Privileges Committee. They can suspend you, the Privileges Committee. They have these unusual powers, suspend you from the House. They can't suspend you as a Member of Parliament. They can't unfrock you, so to speak. But they could suspend you for the House for a period of time. They can censor you formally, which means you've been a bad bugger and you are now being recognised by Parliament as a bad bugger. Or alternatively, they can do what they did in the Tinetti case, which is have this argument about, oh God, she belongs to our side, we can't let the whole House fall on her, she didn't really lie. She acted inappropriately, you know, so you can come to those sorts of conclusions. I'd like to say it's a slap on the hand with a wet bus ticket, and I'm probably right. But as somebody who got pulled before the Privileges Committee myself, or threatened with being pulled before the Privileges Committee myself, they didn't actually in the end, for actually, as I remember telling a speaker to F off, although I use much better words, I did not use the Anglo-Saxon vernacular at all. I just suggested that there was a anatomical feat that I thought that the speaker might be able to perform that would improve his life. But oddly enough, the Privileges Committee didn't feel the same way.